Hello, fabulous friends. Sally the Seeker here. Happy New Year. I hope you all had a safe and happy New Year. Like I said, no resolutions for me. Each day is a new day for me, and I just try to do better than the day before. So, we will continue on with, let's face it, at this point, it really is the Darrell Brooks show. I mean, we have mountains of evidence that he's the one that drove the SUV. There are photographs, videos, multiple witnesses who've identified him. And even when he starts his witnesses, they're going to many will identify him. So it's, I think at this point, he just knows the jig is up. So he's going to put on a show and drag this out as long as he can, being the narcissist that he is. And just go on and on. And I've actually been enjoying watching Detective Carpenter just answer his questions and just still filled with utter disgust and contempt like we all feel. But Darrell, give him a big suit, an oversized suit, a bunch of boxes of papers that he can fiddle around with. And he's a lawyer. He thinks he's a lawyer right now. And he's going to try to be smart, but he's going to ask the same tired questions. But let's proceed and see what he's going to ask Detective Carpenter next. At the last video, we had left off where he had asked about the FBI. Were they still present? And he said they really weren't needed anymore. And Darrell had asked, why is that? And Detective Carpenter said, well, because they realized it wasn't a terrorist thing, a terrorist attack. I mean, and I said, it is attack, but yes, it's not terrorists involved. So they didn't really need the FBI. Although I think Darrell was a little excited that the FBI was there. I think it thought it just will add to his, to the whole excitement of him being the center of attention, which he really loves. So let's watch him love himself, be the star, be the badass attorney that he thinks he is. Okay, here we go.
I'm sure throughout your career you've done lots of interrogations. Are they usually multiple officers that do the interrogation, or usually just one?
It can depend on the circumstance. It's not always more than one, but it can be.
And what would you estimate would be the normal procedure for interrogation as far as law enforcement wise?
I really can't speak to that. I think every department probably has their own potential way of doing things.
Up until that point in your career, when you interrogated the detainee, had you ever conducted an interrogation with FBI present?
Not prior to that date, no.
He is still hung up on that FBI. He's not going to let it go. He's like a crab. He just holds on to things.
Made reference to car key being found. Do you recall that?
Yes, I do.
Did you yourself find the car key?
No, I did not.
How do you know?
Were you told by other law enforcement?
I guess told what exactly?
That a car key was found.
I was not specifically. Your items that were located on you during the search were turned over to Detective Stern, and the car key was one of those items.
And to the best of your knowledge, you didn't have that information at the time, correct?
At which time?
At the time that time that the detainee was detained in the substation?
Thank you for that clarification. Go ahead and answer.
I just want to make sure I guess that I understand. So you're asking me what I knew about the key, or if I knew where it was found at the substation? I don't understand. Can you clarify that, sir?
Don't you dare
I
say.
guess the clarity that you may be looking for is what was found and brought into the substation?
Okay. The Ford ignition key and other items that I alluded to in my earlier testimony include your photo ID and credit cards with your name, or debit card, credit and or debit cards with your name on them.
That you did not search and find yourself, right?
That's correct.
Did you conduct any searches?
I don't recall if I did or not of your person.
So it'd be fair to say you don't know where certain items were found at the time that you learned of there being items found, correct?
No.
No, as in?
No, I knew those items were found on you in the search. Maybe not the specific pocket, but I knew the officers found those items in your possession.
Were you at the scene of the search?
Oh my gosh.
No.
How do you know for sure?
So how do you know where they were found?
Oh my gosh, he's so predictable.
Because they were turned over to Detective Stern as your property.
You know, at this point, he thinks he's trying to be so slick, but did we not already see on the recording and photographs when Detective Carpenter and the other fellow, you know, they had photographs of the key and the ID, and he just thinks, you know, if somebody wasn't there, then it may not be true. It is so ridiculous.
How do you know where they were found, though, if you weren't at the scene?
Oh my gosh.
Because I was aware officers searched you, and it's not reasonable to believe they were randomly in the grass at the house you were at in a city that you've indicated you're not familiar with.
Can you strike that last answer from the record? I didn't refer to any house, grass.
You asked an open-ended question. This answer will stand. Your request is denied.
He gets to pick and
So it'd be
choose.
fair to say that in the question I did not mention a house, grass, or city?
Oh
That'd
my,
be fair to say?
oh my gosh.
You didn't mention it, but I know you were found at a house in the city of Waukesha. And I know you're not familiar with Waukesha because that's what you told me when I interviewed you.
Yep, look at your sticky notes up there.
Can you strike that last answer?
Request is denied.
What grounds, Your Honor?
You asked the question. He answered it. If you want to limit, ask leading questions.
There you go.
Direct him.
Don't tell him, Judge, how to be a lawyer. We love you, but don't tell him.
That is your right during cross.
You made reference to the house where the detainee was found, the grass, the city.
Oh my gosh.
Could it be possible that that's where they were found? The items that you are referring to?
No.
They already showed it on camera that they got it out of the pocket.
Even though it would be fair to say that you were not present.
Just because he's not present.
Correct.
You made a lot of reference to the body pain and having to be checked at the hospital and being medically cleared. Would that be fair to say?
Yeah, because you complained about it.
Yes, we took you to the hospital for clearance.
Are you yourself a doctor or have any training in the medical field?
Wow.
No, sir.
You're the one who
So
complained.
it'd be fair to say that you cannot know how a person's body is feeling. That'd be fair to say?
I'm sorry. Oh, that's a funny expression. That is like the stupidest thing. They took him there because he complained. Oh, my arm, you slammed me down. But we all know he's just making himself look worse. I guess when we become irritated, well, at least me, maybe y'all are irritated with me, we've got to remember that the jury is listening to this and everyone else, and they know how stupid it is too.
I can't explain exactly what another's body's feeling, correct?
So it'd also be fair to say that there's a possibility that you can be incorrect about assumptions made to pain reference. That'd be fair to say?
Again, so stupid.
I think that depends on the circumstance. In this specific circumstance, you told me.
The last follow-up if he wants it.
Okay.
Next questions.
You made a reference on one of the exhibits. I'm not sure exactly which one it was. It was the first interrogation in the police holding room in the hospital. In that exhibit, you made reference to the FBI being present because you were short-staffed. Do you recall that?
I don't recall exactly what I said, but I recall acknowledging their presence, yes.
Okay. So I do believe he did say they were short-staffed, something like that. But again, why are we bringing up the FBI again? We've already, I thought that was asked and answered, and yet here he goes again. I told you, he's very like mesmerized, Darrell is, by the FBI. So I think he wants people to be aware of that.
And you made a reference to short staff. Can you explain what does short staff mean?
Lack of staff.
I don't recall if I said that or not.
I don't know if it's exhibit 172 I'm referring to. Can you pull up exhibit 172, please?
You referred to the photo of the identifiers and the items found?
Is that 172?
172, yes.
Well, I don't think, is it 81 then I'm referring to?
81 is the audio recording.
Okay, it's 81.
I'm sorry, 81 is the video and audio.
Of the,
Was it just the audio? I was right the first time. It's
okay, I think it's 81.
You would like the audio recording from the hospital?
Yes, Your Honor.
Is there a part you'd like to direct the state to when they pull it up?
Because it's the audio, I'm assuming it'd be probably as soon as the defendant is brought into the room.
It was played starting at 4 minutes and 25 seconds through 14 minutes and 25 seconds. Do you want it started right at 4:25?
Yes, Your Honor.
Okay. Do you know how long you want it played, or do you want the whole thing? The same clip?
I don't need the whole thing played.
Just remember what they said about stopping at different places.
What I recall, the point that I will refer to is pretty early in that.
Well, how about we start at 4:25 and then you say pause, please, when you want it to be paused by the state.
Okay.
All right, go ahead.
I'll tell you.
Yeah, he's going to prove his point that he said they were short-staffed, but it has nothing to do with anything.
and Mary. Yep.
They're just kind of helping out because we're so short-staffed tonight. So, thank you.
It's paused at 4 minutes and 56 seconds. Go ahead.
Okay.
From hearing the audio on this exhibit 81, do you recall saying that the FBI was present because you were short-staffed?
That is my voice. I don't recall saying it in the moment, but that's my voice.
That is your voice.
That is me talking.
Yeah.
So from your recollection, do you recall being short-staffed at that time?
Yes.
And can you explain what the short-staffed mean as far as at that time, what would short-staffed mean?
That we were just very short on resources with what happened down at the parade route and the mass casualties and the amount of officers it took to secure that location. We were very short on people.
And
People were called in off duty.
You made reference to the short staff being the reason why the FBI was present.
Yes.
What's your point? What's your point?
Is FBI usually present in the situation of short staffing?
No.
It's the magnitude of your crime, bozo. Don't get all big-headed about it, though.
Maybe put that off or if you
Yes,
need it.
I'm sorry.
No, that's okay. I just want to make sure if you needed it, it's up. All right.
So
It's taken
Tyler, I
down.
can get his too.
See, I think he's trying to act like the detective Carpenter's pulling a fast one on him, but
And you made reference to
he thinks
recording the interrogation on your phone, correct?
Yes.
And why would you use your phone to record an interrogation? Especially one of this magnitude.
Because the camera in the room didn't have audio capability.
And were you informed of that? Or let me back up. When were you informed that the camera that was in the room did not have audio?
I don't recall exactly. Prior to the interrogation.
And who were you told by?
God.
Hospital security.
Was that the first time you had ever used that police holding room in that hospital?
No.
So it would be fair to assume that you were aware that that room had cameras.
Yes, I knew it had cameras.
And have you ever conducted an interrogation in that room before that evening?
Interrogation, no, but I'd use the room for other purposes.
So what prompted an interrogation in that room that specific evening?
Well, as I explained in my earlier testimony, the situation down in the downtown area, Waukesha, where the mass casualty incident had occurred, was very fluid. It was still unfolding at that time. We were learning more and more and more about what occurred. We decided to start the interview at that location to see if you'd be willing to shed light on for us as to what you did or did not know. And again, I'll go back to the statements I made earlier. There's a risk inherent with every transport. I didn't know where your ultimate final location was going to be that night, so to now start bouncing you from facility to facility to facility unnecessarily was just something we made the decision not to do.
And at some point, the detainee was moved to the Muskego Police Department, correct?
Yes, you were moved to the Muskego Police Department later in the evening.
And when did you learn that that would be a location that the detainee would be going to?
The detainee being you.
We made the decision to try to use that location after the first interrogation attempt.
I'm sorry that I didn't hear the last part.
I'm sorry, after the first interrogation attempt.
First interrogation attempt. How would you define attempt?
Well, when we were at Waukesha Memorial Hospital that night, in the police holding room that we've discussed, I read you your Miranda rights verbatim from the Waukesha Police Department Miranda statement form. And at that time, you indicated you didn't wish to speak with me.
So it would be fair to say that the Fifth Amendment right was exercised at that point.
Right to silence.
Under the Fifth Amendment.
Yeah.
So, acknowledging now the fact that the Fifth Amendment right was invoked not to speak, or as you say, the right to silence, why did you continue to record on your phone?
So we are trained at our police department, when you do an interrogation, the recording is to be left on pretty much until you try to effect transport. So typically what we would do is, if our building hadn't been under construction, and when we'd been able to get you back to our police department, where in that situation we may very well have transported you, just because we would have had a municipal lockup there and we could have held you for the night. But that again was difficult based on the fact that we didn't have that possibility at the time. So if someone's in an interview room and at our police department, we'll leave that, even after the interrogation's over, we'll leave that video running until we come back and remove the individual from that room.
Even once a detainee has invoked their right to silence, you still continue to record? Is that a standard practice of your agency?
Yes, it is, for as long as they remain in the room.
And so when did you start recording?
Are you talking at Waukesha Memorial Hospital?
Correct.
Prior to you entering the room.
So you started recording before the detainee entered the room, and you said you keep the recording on until they leave the room. So would it be fair to say that there should only be recording while the detainee is in the room?
No.
Darrell, please quit acting like you know everything. You know nothing.
And you did say for the record that that's standard procedure in your agency.
In regards to the interview rooms at our normal police department, which wasn't available at that time, yes.
Would it be fair to say that you were not at the normal police department?
Oh, God.
Yes, however, with the audio, I was still trying to make sure I followed the policy to the best of my ability.
Can you show proof of that policy?
I don't have it.
What, he's going to carry it with him
Would it be
everywhere?
fair to say that there's no way to determine if that truly is policy if it can't be proven? Grounds.
Sustained. As to the form of the question, it's argumentative.
How can that policy be proven?
Objection.
Grounds.
Sustained. On relevance grounds.
Nice try. You could have asked him to bring it with him, but he didn't know what he was going to ask him. If he prepared, you could have asked him to bring it with him. But you did not.
Do you know where that procedure is located in your agency rules?
Objection.
Grounds.
Relevance. Sustained.
Grounds for the sustain, Your Honor?
Relevance grounds.
Keep asking the same thing.
Relevance. Not relevant.
Oh, my gosh.
This is not relevant?
No, keep going. We can take it up later outside the presence of the jury at our afternoon break, but for now, keep going.
I follow, Your Honor. I apologize.
Keep going, okay.
Yeah, just keep going. Don't apologize. Apologize to the victims.
So once the the detainee was taken to the Mosquito Police Department.
You said call it the mosquito?
That would be a pretty standard police department. Would that be fair to say?
Yes.
And a second interrogation also took place at that police department, correct?
Yes.
Any reason why the first interrogation couldn't take place at the same police department that the second one took place at?
Well, the first interrogation, again, wasn't at a police department. You know, Mosquito was utilized as they had a lockup facility. So we interviewed you there.
Around what time was the detainee taken to the Mosquito Police Department?
I don't recall the exact time.
And you also stated that another law enforcement
Mr. Brooks,
officer.
I apologize for the interruption, but I just want to make sure my jury is in good shape. If you want to just take a moment to stand. It's a little slow, I think, for them, so we're just going to stand for a minute.
Yes.
Again, my apologies for the interruption.
Yeah, especially since he's doing a very, very long cross-examination. And he's like, oh, good. I have a captive
Anyone on my jury need
audience.
a break? Are we good? I'd like to keep going. Anyone? Okay. No response to that. They said they're good. All right, we'll sit back down. And again, my apologies, Mr. Brooks. Hopefully you know where you were.
Yeah.
Okay.
It was another law enforcement officer who actually did the transport of the detainee at that time, correct?
Yes.
Mm-hmm.
And you stated earlier in testimony that you and your partner followed behind that transport. Is that fair to say?
Yes.
And I'm assuming at some point that you will actually strike that. You stated to being present during the booking process into the Mosquito Police Department. Is that fair to say?
Yes.
So why couldn't interrogation be conducted at that time, which would have been more ideal considering that you said there was a lockup. I forgot how you referred to it, but basically like a room where the detainee could be secured.
I feel like, maybe I'm mistaken. Tell me if I'm wrong. Hasn't he been asking the same question over and over again, and it's been explained, but maybe that's just me. His redundancy is so tiring, and he's just such a miserable human.
Well, you had been talking about at that point when we arrived at the facility with you that you hadn't eaten all day, you hadn't slept, so we wanted to give you an opportunity to eat, sleep, clear your mind, and refresh yourself.
And what bearing would that have on interrogation?
Oh, God.
Well, I mean, you said you hadn't eaten, you hadn't slept. So I think a person is more focused when they're fed and they're rested. So we wanted to give you the opportunity to do that.
And in your opinion, how would that have affected interrogation?
Okay.
Excuse the jury right now. So if our jury, we could stand for the jury so I can take up a legal issue, please. All rise.
Oh, okay. What is this?
right, thank you. Be seated. So I'm going to take up two issues right now. One is when I paused earlier and told Mr. Brooks I would allow him to, it was regarding the policies. I want to know, as the proponent of the evidence, why you think that's relevant. And then secondly, the questions I believe that you are asking related to the interrogation, unless you can convince me otherwise, go to a legal issue that this court has already determined. But I'll hear you out on that. I didn't want to make an assumption, but I also didn't want to have you question this witness about what really are legal issues that this court previously addressed regarding the admissibility of the interviews.
Well, to the first one, about the policies, that's relevant because I think it should be stated for the record why he left his phone recording after he acknowledged that the Fifth Amendment right to silence had been invoked. At that point, interrogation is supposed to stop completely.
Well, I understand what you're saying from a legal perspective, but that doesn't mean the recording had to stop in and of itself at that point. He did provide an explanation on the record.
His explanation was that it's policy, right?
He answered the question, why do you believe having a specific policy and him testify about the specific policy is relevant to his testimony?
Well, I believe that if that's in fact the policy, it should be proven. It should be proven that that's a fact, that is a real policy. For all we know, he could just be saying that it's a policy. And at that point, it makes him continuing to record after the Fifth Amendment had been invoked.
Well, right now, you assume facts that are not in evidence, sir. And so you're the proponent of this testimony through your cross-examination. And so without something more, sir, I don't see where there's relevance as to what the specific policy is.
Can you see what I'm getting at, though, Your Honor? If he's saying that this is a policy of his agency, he should be able to prove that that's policy. Because at that point, if there's no way to know that that is the correct procedure that they use every time, then why?
And making a lot of generalizations that I don't think are accurate as to what he said. This is a trial, sir, where the allegations in this case are that you drove through the Christmas parade, right, and caused death and injury to a number of individuals. There's also those other charges related to the bail jumping, the battery, and frankly, his conduct isn't on trial. We're not here about a police misconduct trial. I'm not saying that some of this information might not be relevant to his credibility, things of that nature, but you have to, again, you're the proponent of this. Why do you believe those policies relate to an issue of fact in this case or otherwise go to your defense?
I believe that is relevant because it can show that at the very minimum that first interrogation and anything related to it should not be admissible as evidence.
That's a legal determination that
Wow.
I've already raised. Your attorneys represented you at that time. They made a variety of arguments. So to then make this trial about that interrogation, it's not relevant.
I'm not making the whole trial of it.
But the issues are legal issues that this jury will not be asked to answer. I've already ruled on the admissibility. That's a legal determination. So I'm not seeing the relevance to those specific policies, and there is simply no requirement that the state or this witness has to prove those policies. You are representing yourself. Hold on, let me finish. You're representing yourself. I'm not aware of any subpoena that required him to bring those policies with. So that would have been on you if you felt it important to cross-examine him on those policies to require that. I'm not aware of that. Have you done that?
Obviously, it was going to come up
Did you issue a subpoena ducus tecum to this witness to bring with any of his policies
How
related
can
to
I do that
interrogation?
myself, Your Honor? How can I do that from a jail cell?
You were given all of those
Uh-huh.
blank subpoena copies, sir. And
See, just what I was saying, because it will say, bring what files, documents with him. So if he had been well prepared, he would have thought up this ahead of time about the whole policy thing. And again, ill prepared. That's why you should have had an attorney.
and you could have filled that out in a way for this witness to require. You didn't do that.
So who would have served him?
The state would have. They served your other subpoenas. But be that as it may, that's not what we have here. So I believe that your line of questioning is on a topic that's not relevant to the issues in this case. So I'll give you one more opportunity. Why do you believe that questioning him about the policies are relevant to your case?
It's relevant to the case because why would he be recording before people are even in the room and then after?
Well, that's argumentative, sir. So that's not a legal basis.
Once the Fifth Amendment is invoked, interrogation is supposed to stop. Period. There's supposed to be no more recording, no more questions asked. That should be the end of the whole interrogation.
These are legal issues that you're trying to raise before the jury. I've already dealt with the admissibility, so you've not provided a legal basis to further question this officer about policies related to the interrogation and the recording. He has answered questions. I gave you some leeway on that, and his answers are before the jury. Certainly you'll be able to argue the meaning of that or the lack thereof during your closing arguments if we get to that point. Let's move on, though, to this issue about why I excused the jury. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
I believe you were attempting to elicit information or evidence, testimony from this witness on issues that are not relevant.
Is that referring to the same question?
Not the policies, what I just stopped the testimony for, because I don't want to create issues in front of this jury related to legal issues that are not before them to determine.
And is that referring to the question about the policies?
No. You were asking him, why did you stop? Why did you not question him further? Meaning, why did this detective not question you when you got to the Muskegon Police Department? Why did they wait till the next day? I stopped because I know the law on this area, and I know that when a subject invokes their Fifth Amendment, or when you're a defendant in state, it's the 14th Amendment, but nonetheless, right, you have rights under the Wisconsin Constitution as well, but that because you only invoked your right to remain silent, they waited to question you until a sufficient amount of time had passed, in addition to the other reasons. I'm not going to let you question him in front of the jury about that specific thing. Or at least I'm cautioning you that I'm stopping it because I don't see where that's relevant, but if you keep pressing him on that, you're going to open up the door to him saying, because I was following the constitutional requirements and giving you a break in the questioning so that I could, get a statement I believe would be admissible later on. That's what I'm trying to avoid.
With all respect, Your Honor, I don't think he would have said that.
My concern was we were headed down that path. So if there's some other reason you want to question him.
The 14th Amendment would have been referring to the having the attorney present.
I'm sorry, say that again?
So you said, when you stated that you know the law in that area about the Fifth Amendment and the 14th Amendment, what were you referring to on the 14th Amendment?
I'm not going to explain that any further, sir. Let me just ask the state if they see this any other way, if you think I'm mistaken, and I was concerned we were headed down that path, which would be a legal determination, but if there's something the state sees that differently, please let me know.
I actually thought that Mr. Brooks was questioning this witness about why they didn't do the first interrogation at Muskego. So I thought that there was some miscommunication between the two of them. And I just wasn't sure. I didn't want to object for that reason because I just wasn't sure what Mr. Brooks was talking about at that time.
Well,
And
that's fair enough, because if that's what you were trying to question him
I
on,
agree.
then I think that's fair game.
I
But
agree with Attorney
might have been
Basie.
interpreting
That's
it
what I was
differently.
getting at. I didn't mean to cut you off,
Go
but I
ahead, go
agree
ahead.
with Attorney Basie. That's exactly what I was getting at.
All right, well, you understand it's my job to protect the record too, so I want to make sure that, all right, so with that understanding that you are questioning this witness about why they didn't take you to Muskego for the first interview, is that where you're wanting to go with all of this?
That was the question.
All right, well, I might have misunderstood, but in any event, it gave us an opportunity to talk about the other things, so that's okay.
So is that a fair question to ask then? Just because I'm confused now if I'm even allowed to ask
Don't
that
give him
question.
I
advice.
think part of the
Get a
issue
lawyer.
sometimes, sir, is there's either, sometimes the questions aren't as artfully worded as they could be. I know you're doing your best. I like to look at it this way. Questions that are a sentence at a time, meaning a thought at a time, because then they're not compound, are the easiest for a witness to answer. And when you start bringing in other things, it can be confusing, and then I might not understand, or a party or a witness might not understand what you're asking. So looks like it's one of those situations where I was a bit unclear. It's been clarified. If that's the line of questioning that you are going to go, then that's fine. Then I would allow that. I'm not going to stand in the way of that. If the state objects, obviously that's a different story, and then I'll have to rule on it. But I think we're all on the same page now.
And just for the record, Darrell, I will be objecting. I don't want there to be, just because I think this has been asked and answered. He was taken to Wexford Memorial Hospital for medical clearance. They want to minimize the number of times that he's transported.
Thank
They
you.
needed
Thank
the
you.
information
Same thing I said.
sooner rather than later. So I will be objecting as to asked and answered. I just didn't want to, he asked the question that the court suggests, and then I object, and so I do want to put
Yeah,
that
she
on
was
record
being
just so the court's
fair to
prepared
him.
for it.
Understood.
The question of why wasn't the first interview conducted at Muskego Police Department had not been answered.
I'm going to let you ask that question. So even if they object, we'll put everyone on notice. So because I think it's reworded a bit differently. I think it's fair. I'm going to let you ask that. All right?
See what happens.
Let's bring the jury back out. I might have to get me more water too. Thank you so much. You have enough water, sir? You have water?
Yeah.
You have enough?
Run through this one.
All right, we'll make sure there's another one. All right, I can't see behind the calendar. Which got or don't take.
Thank you.
Enjoy that little treatment, because once you get in that little cell, you won't be getting your bottled water. Thank you. Yeah, no manners.
All right, thank you, everyone. Please be seated, and Mr. Brooks, you may continue with your questioning of this witness.
And do you recall why the first interview was not conducted at Muskego Police Department?
Yeah, so in regards to the first interview at that point, as I kind of stated in my earlier testimony, we didn't know exactly where you'd end up. Muskego didn't become an option and something we thought of as a final place for you until after the first interrogation was attempted and was over with.
And do you recall if you made that determination yourself, or was it your supervisor or something of that nature?
Objection, relevance.
Ground.
As to where they were going to take you?
Yes.
Overruled. The witness may answer.
I discussed it with Detective Casey.
And at that time, that's when you learned that Muskego Police Station was a viable location.
Yes, that's the point at which we made the decision.
Had you ever used that police station before in any of your investigations before that evening?
Objection, relevance.
Grounds.
Overruled. The witness may answer.
I had not, but when our department first closed, that was given as an option for us, being we didn't have our own municipal lockup.
And do you recall around what time you started to conduct the second interrogation?
Yes, 12:11 p.m. on the 22nd.
Impressive. He remembers.
And do you recall how that interrogation started?
Yes, I explained to you I had more information about the domestic, and that's what I was looking to speak to you about.
Do you recall making a statement that we all know how women can be? They're crazy?
I do.
You know what? I believe that's been asked and answered, because I can remember Attorney Basie asking him during her direct examination pretty much that very question. Do y'all remember that, if you've been following along? But she might object, or maybe she'll just let him go on and talk.
And what did you mean by that?
It was just additional rapport building that I've talked about in my earlier testimony.
Yeah, see, earlier testimony.
Speaking to you on a person-to-person level, quite honestly, it wasn't a judgment I generalized towards all women in the world. It was just wanted you to feel comfortable talking to me as a person. I felt we had rapport. I felt I could tell the night before you were comfortable speaking to me. And it was just a continuation of that.
So it'd be fair to say that that comment doesn't reflect your opinion of women.
Correct.